Welcome, everyone, this afternoon. You are in for a great afternoon of learning. We have the famous Soo Hoo with
Oh
us,
gosh.
and she is truly one of our state experts in the area of special education. And these sessions are always focused on leaders. What do leaders need to know in order to not only be in compliance with special education, but also to do what's best for our children on an IEP? So she keeps us out of trouble, and she keeps us really thinking about how to make sure we're doing our very best for the children we serve. So with that, I'm going to turn it over to Cindy, and thank you for taking the time to be with us today.
Oh, well, thank you. Thanks, Leanne. That was very sweet of you. I had no idea you were going to introduce me. So yes, I'm used to jumping right in. So I greatly appreciate the introduction, and I greatly appreciate the support and the opportunities to work with you and your teams and the cohorts who come in. I just find this to be really a passionate area of mine, and hope that I can instill that information to those out there listening. So I'm hoping that the information they received thus far has been helping them in their journey along the way, whether they are right now in a leadership role or soon to be, but hopefully the information they find to be very helpful. And as always, I appreciate the work of Selena. She's our webinar facilitator, and the skills behind the technology portion of it, where I don't even have to focus on technology. I can just think of the content and what I want to impart to everybody. So thank you so much. And of course, Tara Summers, who's just been wonderful as well, and Leanne's right-hand person, just a great team. So thank you so much. It's a wonderful opportunity. So welcome everyone to session 5. As Selena said, we've come a long way. We are just really 1 month away from finishing up our 6-session series on special education. And I just kind of want to take this opportunity to, again, just review a little bit about what we've kind of covered, just to kind of get you thinking about what we've done in the past, and then kind of give you an idea of where we're going this evening. So we've had an opportunity to kind of start in on special education and talk about really the creation, if you will, of special education, with all the different sources and regulations and rules that kind of govern the work that we do. And we had a chance to talk about the standards that really apply in terms of what it is that we are expected to do in the field of special education, and more so in terms of FAPE, the FAPE standard, or a free appropriate public education. So that's kind of where I started when we all came together. I talked about how we kind of came together in terms of special education back in 1975, and how we've evolved over the years. And so we had a chance to really kind of talk about the overview of regulations, statutes, rules, and other sources that kind of govern the work that we do. We also talked about the idea of communication and how important that is. And oftentimes, parents will feel either that there's been a lack of communication or miscommunication or whatever the case may be. And that sometimes becomes the impetus for why parents file. And so we talked about the importance of really working with individuals, working with the parents, and kind of getting an idea as to what their concerns are, so that you have the opportunity to sit down and kind of work through whatever those issues are and take care of them before they become really huge issues that may end up in either a state complaint or in a due process hearing request, which is obviously something that we don't want to happen. We don't want to have to go through that. And also, first and foremost, we're really here for the students. We want to make sure that the students get what they need. So first and foremost, it's really about all being child-centered, and making sure that we focus in on them and their individualized needs. We then went from there to kind of the special ed process, starting out with the response to intervention and the multi-layered systems of support and evaluations, and then went straight into eligibility determinations. And we talked about the two-prong approach in terms of the student having to have a presence of a disability and the need for special education and related services. And we defined what that was. We then went into the third session and talked about facilitating a compliant IEP, how facilitation of an IEP is also important. Not only is the final product important, but the process by which we walk through the parent through that journey is also very important, that we provide them the opportunity to meaningfully participate in the process. And then the last session that we did, session 4, we really focused a lot on the special education components of the IEP, kind of the more prominent components, if you will. We talked about present levels. We talked about goals that lead from that, and how when you have a very robust and comprehensive present levels of academic performance and functional performance area of the IEP, that helps you build those individualized goals for students. And then how important it is to really make sure that we are monitoring those specific goals to make sure that the students are in fact making appropriate progress. We also talked about the need for looking at the least restrictive environment for students. We briefly talked about kind of the difference between full inclusion and how that was more of a philosophical approach, or a philosophical view of where students should be placed in terms of their special education services, but it's more so along the lines of least restrictive environment, and how we have to have that continuum to where we determine where on that continuum students would be placed based on their individual needs. And then we also talked about the prior written notice and how important that is, and under what circumstances we need to provide a prior written notice to parents. And so throughout, I will continue to bring up a lot of that information, because it really is so intertwined into one another. Okay. Tonight, we're going to just focus on discipline. So each of those sessions that we've done in the past have kind of been combined with several different topics, just, as they hopefully kind of mesh together. But tonight, we're really only going to talk about discipline, and I'm going to do my best to make this as clear as possible, because it is very confusing when it comes to working with students in special education, and also students who are not quite eligible for special education, applying the discipline rules that we have in both state rules as well as federal regulations. And so I'll have an opportunity tonight to hopefully impart that to you, and you'll have an opportunity at the end to ask questions. We'll have a moment in just a moment to take kind of a quiz. Selena's going to provide for us just a quiz on screen, and it gives me an idea as to what your kind of knowledge base is at this point in terms of special education and the discipline process. And then we'll have an opportunity to cover that information and then review it at the end when we're just about ready to part this evening. But throughout all of that, we always will provide for you the regulations that govern the special education processes. And so you'll see that introduced whenever it's applicable. It'll be on your screen, and so you're able to put that into your toolbar, and into your search bar, and you'll be able to go right to that portion of IDEA or that portion of New Mexico Administrative Code and so forth. So really, we'll have a chance to kind of get an idea as to what the most compliant issues are or non-compliant issues are as we go through this evening. Okay. All right. So with that said, let me just kind of give you an idea as to what we're going to cover this evening. So as I said, it's going to just cover special education, the discipline process. And so we'll have a chance to just talk about a couple of court cases that really kind of paved the way, if you will, for the special education processes that are in place today. So we'll have a chance to kind of review those cases and get an idea as to how they actually kind of shaped the regulations that were to come at a later date. I mentioned you'll have an opportunity to just kind of take a quiz just to kind of get an idea as to where you are in terms of kind of knowledge base. We'll talk about the 10-day rule. You might have heard something like that and how it applies really to students. in special education and what that means in terms of services for students. We'll also talk about in-school suspension and what to make sure needs to be in place for it not to count as days of removal for students. And we'll also kind of review a court case that will hopefully drive home the fact that sometimes in-school suspensions might be used too much in excess for students in special education. So we want to be mindful of that. We're going to talk about what a change in placement is, and that hinges on so much of what you're going to do in terms of special education disciplining. And so I want to make sure that we drive that home as best we can. We're going to then obviously cover manifestation determination reviews because the two go hand in hand. We're going to talk about a pattern of removals and what that means in terms of change of placement. We'll also have an opportunity to go over the manifestation determination review process. We'll talk about under what circumstances you would need to conduct one, who needs to be basically involved, what kind of timeline would you need to follow, what are the two questions that need to be asked when we are determining whether or not the child's behavior is a manifestation or is not a manifestation of their disability. We're going to talk about maybe some questions or some information that you might gather, that you might ask or you might gather in order to answer the two required questions. And then we're going to talk about what kind of options exist when it's determined that the behavior is or is not a manifestation of the child's disability. And then finally, we're going to talk about special circumstances. There's this particular category called special circumstances and what kinds of behaviors fall under those. And we're going to talk about dangerousness and what kind of options schools have, administrators have when they believe that a student is too dangerous to be on campus. As I said, throughout all of that, I will always give you the citations that are applicable for the information that I'm passing along to you. And so you can see there that it covers several different sections or several different regulations of IDEA. The CFR, as you know, is Code of Federal Regulations, sections 300.530 through 536. So if you were to put that in your search bar, you would end up with all of the discipline information under IDEA. And then before we end tonight, we'll have an opportunity to kind of talk about a court case and have you participate in where you're going to be a judge and you're going to determine how you think the judge had ruled in a particular situation, a particular case, based on a student who was found to obviously be not in compliance of the student code of conduct. Okay. All right. So with that said, I'm going to turn it over to Selena. She's going to pose for us just a quiz. It's only going to take about 5 minutes. There's only about 10 questions. So we'll have an opportunity to see how everybody's doing in terms of being able to answer all of the 10 questions. Then we'll move on. We'll save those answers for the end, and we'll have a chance to review them when we finish. Okay. Let's talk about how it began. Like how did we get here, really, in terms of the behavioral process, the discipline process under IDEA? I'm going to share with you a court case that happened in Florida. This was back in 1981, and it's S1 versus Turlington. S1 means student one versus Turlington out of the Fifth Circuit. As I said, it was in the state of Florida. This was a case that involved several students who had been expelled from school for almost 2 years, which by basically their state rule was, or state statute really was the maximum penalty for expulsion. The students had basically been involved in a lot of infractions that included what you see here: profane language, vandalism, willful defiance of authority, and even sexual acts against other students. All of the students who were involved they were eligible under the category of intellectual disability. And now we know that that was a different eligibility category back in 1981, but we have today looked at students who have really low cognitive abilities and very low adaptive behavior skills as falling under the category of intellectual disability. So these are the students who were involved. At the time, the school superintendent and the school board came together and did a manifestation determination review, if you will, of the students, and they determined that the behaviors were not a manifestation of the children's disability or the student's disability, meaning there was not a substantial relationship between the student's eligibility category and the behavior that the students actually exhibited. And so they found that it was not, there was no basically substantial relationship between the two. And what they hinged it on is that they said that because student one, meaning S1, didn't have an emotional disturbance, that the behaviors were not related. And so I'm going to share with you what the Fifth Circuit decision was, and kind of talk to you in just a minute on a subsequent slide on how we've kind of evolved from this court case that happened in 1981. Okay. All right. Well, the Fifth Circuit came back and obviously found a lot of fault with the analysis that was done here. They said, first, the school officials should have made a determination as to whether or not there was a link between the disability and the behavior with all of the students, not just the student that affirmatively raised this. So you see that it's S1, meaning student one, but obviously there were multiple students in this court case. Secondly, the court rejected the idea that the determination hinges on whether or not the student was identified as having an emotional disturbance. Not sure where they came up with that, not sure why they thought that the only eligibility category that they would have considered would be ED or emotional disturbance. Third, the court found fault with this determination being made by the school superintendent and the school board. Instead, the court ruled that a termination of services brought about by an expulsion amounted to what we call a change in placement. And you're going to hear that term over and over again tonight. And I just want you to kind of, put that in your brain, change in placement, okay? Because we're going to talk about what that is and what you have to do if the discipline that's going to be imposed will result in what we call a change in placement. They go on to say, thus, it should have been done by a specially trained and knowledgeable group rather than simply by the superintendent or school board. Okay, so you can see this is in 1981. Remember, we had the Education for All Handicapped Children's Act that started in 1975. So 6 years later came this court case that got up to the Fifth Circuit, having to do with the manifestation determination process and what they used basically to make that determination. Okay, so that was 1981. Let's move on to Honig versus Doe that happened in 1988. Very well-known court case that's often used today in many, many court cases. This one went all the way up to the Supreme Court. So the last one was a circuit court. This is now the next level up, the Supreme Court. This involves students in the state of California. These students were basically very violent, had attempted to choke another student. They left, their marks on the victim's neck. The school officials wanted to basically remove the students because they felt that the students were too dangerous to have on campus. They said that they didn't think what's termed as stay put would apply here because the students were too dangerous. Stay put means that whenever a parent files, let's say, a due process hearing request, they have the right to invoke what's called stay put, meaning the student stays put in the current placement, in the placement they are in or that they were in when the behavior was exhibited, okay? So here we have school officials who thought stay put shouldn't have been invoked because the students were deemed to be too dangerous. They felt that really Congress didn't really mean to tie their hands, didn't really want to kind of usurp their authority in being able to remove students from a campus because of the dangerousness, okay? Well, here's what the US Supreme Court said in this case, okay? By the time this case made its way to the High Court, only one issue remained. Does the stay put rule apply when students have engaged in dangerous, even violent behavior at school? The stay put rule at that time specified that, quote, during the pendency of any proceedings conducted pursuant to the law, unless the state or the local education agency agree, and the parents agree, the child shall remain in the then current educational placement of such child, unquote. School officials argued that this state put provision was not intended to apply when students had committed offenses like Doe and Smith had done. Surely, they argued, Congress did not intend to usurp the authority of local officials to maintain a safe school environment. Surely it did not intend to override the judgment of professional educators as to what kind of behavior is, quote, dangerous, unquote. The Supreme Court in Honig versus Doe rejected those arguments. It could find no language in the law supporting the school's argument. The stay put rule contained no exceptions. Moreover, the court reasoned that Congress definitely did intend to limit the authority of school officials. They say, basically, we think it clear, however, that Congress very much meant to strip schools of the unilateral authority that they had traditionally employed to exclude disabled students, particularly emotionally disturbed students, from school. If school officials believed that a student was dangerous, they could suspend the student for up to 10 school days. The stay put rule did not apply to such short-term actions. If school officials believed that a suspension of more than 10 days were called for, they could seek relief from the court, okay? So those are two cases that I think are really, really important for us to have a conversation about this evening. The S1 versus Turlington having to do with the manifestation determination process and what that should look like. That you'll see on the next slide of how that has evolved. And then the dangerousness clause and what really exists as options for school administrators, what you all might be faced with in your day-to-day operations of a school, okay? So let's see what has come about. Well, here's what it looks like in terms of discipline under IDEA that really has kind of evolved from those individual court cases. And so you remember that we started out in 75 with the Education for All Handicapped Children's Act. We then looked at really that evolving into the Individuals with Disabilities Education Act of 1990. In 1997 was another reauthorization. In that year, for the first time, information was given. IDEA ended up spelling out how, when, and by whom a manifestation determination was to be made. And so that really helps schools understand what that process should look like. If you remember in terms of Turlington, S1 versus Turlington, it was the school superintendent and it was the school board that kind of made that decision that the behavior was not a manifestation of the child's disability. And then of course they looked at emotional disturbance being that particular eligibility category that they were considering. And so now we have, as of 1997, those regulations in IDEA that kind of spell out what it is that we need to do. And we'll go over those as the time goes on this evening. They also looked at what we call the interim alternative educational setting. That's a setting where students can be placed for up to 45 calendar days back in 1997. That now then in 2004, when it was reauthorized, we now look at up to 45 school days. And so now schools have more time to place students in an alternative setting under what we will consider and what we'll talk about special circumstances. Yes, Mercy is, you have a question? Sorry, go ahead.
Hi.
Hi,
I
Mercy.
just want to make sure, thank you for this information. I just want to make sure I'm understanding this right. Manifestation determination, is that just the student's IEP, like the oh my gosh, I'm forgetting it. You know what I'm saying? Like the IEP determination? What is manifestation determination? What is that?
So I'm going to go over that in just a bit, but manifestation
Okay.
determination is a process that happens when a team of individuals come together and they do an analysis of whether or not the child's misbehavior or misconduct is substantially related to their eligibility
Their
category,
disability. Okay,
their
okay.
disability. Does that help?
Thank you. Yeah, I just
Okay.
thought thank you.
Okay, not a problem. I'm glad you asked. Thank you, Mercy. And we'll have a chance to go over that, okay? Okay, so you can see in 1997, when IDEA was reauthorized, obviously for the first time, it was spelled out as to what that manifestation process is going to look like, okay? Who's going to be involved? When do we need to do it? How are we going to do it, basically, okay? And at the time, there was an option of placing students in what we call IAES, or interim alternative educational setting, for up to 45 calendar days. That would include weekends. That would include summers. That would include, spring break, winter breaks, and so forth. Okay. We move along to 2004, when IDEA has been reauthorized again. And that is, by the way, the last time that IDEA has been reauthorized. So we've had 21 years basically without any kind of changes to IDEA. Okay. But there had been some significant changes that had occurred as a result of input from parents and so forth, having to do with behaviors. But one option that actually helped schools was changing that IAES from 45 calendar days to 45 school days, meaning students could be placed in an alternative setting for up to 45 school days, and you don't count the weekends, you don't count the spring breaks, and so forth. Okay. At that time, also, the category of special circumstances had only included weapons and drugs, and serious bodily injury was added to that. Okay, and we're going to talk about that, so not to worry. But basically, the category of serious bodily injury was added to the category of special circumstances that would allow different options for schools to consider if, obviously, the child's behavior ended up falling under the auspices of that. Then there was also a dangerousness provision added. Okay, so if you remember the Honig versus Doe of 1988, where the school staff thought that they could unilaterally remove the students, okay, there's a dangerous provision that was added to that as a result of it. Okay, so that kind of gives you just a little bit of a background as to kind of how we got to where we are today. All right. Okay. So the public education department has really kind of focused in on a more restorative practice kind of reaction or process or response to students' misconduct. And so over the years, especially since the throes of the pandemic, especially since 2020 or actually 2021, when students started coming back, there was kind of a push by the public education department to really look at how we were disciplining students and trying to look at whether or not we needed to take a more therapeutic approach as opposed to a disciplinary approach to students when they basically misbehave and so forth. And so what they did was they back in 2022 kind of launched an initiative that really looked at improving school attendance and at the same time reducing suspensions and expulsions, and really looking at the way in which the schools were going to handle the idea of disciplining students, if you will. Okay. And so let me is there anyone who's kind of seen this within your school district? I'm just wondering kind of how the schools have seen any type of initiative from the public education department. If you've seen anything like this, anything where the public education department has come in to kind of work with you in looking at a different way of maybe handling misconduct and so forth? Francis, have you seen that?
I have. I actually
Oh.
think it was maybe prior to the existence of this coordinator. But during COVID, we worked closely with the school health division of PED and used our school, our social emotional learning grants to bring restorative practices into our school.
Wonderful. Okay. Okay. That's good to know because I'm not sure how widespread it had been around the state. Wonderful. That's good to know. And so basically what they did is they hired a coordinator to really kind of take a look at this, and they wanted to really focus on trauma. And so a lot of the trauma informed practices was being emphasized or were being emphasized. What they did was they looked at the definition of trauma, and they looked at it as being something that a child obviously would experience that would impact them socially, emotionally, as as Frances was talking about here. They defined it as including abuse, neglect, homelessness, domestic violence, or community violence. And they said that it basically affects children's brains and behavioral development. It can cause hypervigilance and impact their memory and executive functions, and including the ability to pay attention, plan, and think things through. And so oftentimes, obviously, if students don't have those skills, they might maybe demonstrate behaviors and not be able to kind of think things through. And so what they really looked at were restorative practices that they are saying that are based on principles of restorative justice, an approach to understanding and responding to crime in society or misbehavior in schools, by emphasizing how such actions harm people, relationships, and communities. And so basically the coordinator was hired to kind of work with the different school districts to provide technical assistance and also professional development in trying to really look at increasing school attendance, decreasing suspensions and expulsions. And so that's been basically an initiative that the public education department has implemented. Something that the Department of Education has also looked at is along the same lines. And so this came out just right after the information came out from the public education department. But really what they were doing is trying to, again, minimize the number of students that were being expelled or suspended across the country because of a lot of an uptick in behavior, especially since returning to school. And so what they really looked at was the number of kids that had been suspended. And really, when you looked at it, you looked at it specifically for students with disabilities or students of color. It was more than 1.5 million students who had been suspended. And, that's quite a number of kids who were out of school. And so at that time, the U.S. Secretary of Education, Miguel Cardona, said, too often students with disabilities face harsh and exclusionary disciplinary action in school. The guidance that they then released will help ensure that students with disabilities are treated fairly and have access to supports and services to meet their needs, including their disability-based behavior. And so the impetus here was to try to really get school districts to kind of take a look at how, again, that they were addressing the behavioral infractions that students were exhibiting. Now you can imagine it wasn't all, support for this, because a lot of school districts across the country were pushing back. They were saying that, it wasn't working, that what they were doing wasn't working. Now critics of that would say, well, then you haven't really given it enough time. You haven't put enough money into it. You haven't put enough time and effort into it. And so it's been a kind of a back and forth, really, in terms of disciplining students as to whether or not we use a more therapeutic approach or use a more of a disciplinary approach. Well, something that the public education department also took a look at is really trying to provide opportunities for counselors to be hired in order to help with the kind of the mental health crisis that schools were experiencing across the state. And so this was a proposal that was done by the public education department to get more people to kind of go through that pathway to become a counselor. And what they found, really, that's the state ratio, this is an unheard number, is like 426 students for every one counselor. And I mean, that's huge. I don't know how, students can get independent kind of support and help from a counselor. And so what the public education department was doing is basically taking a look at a different pathway. And, you know, they weren't getting rid of counselors. They were just trying to find other ways for counselors to be able to, for people to kind of go through that pathway and for us to hire more. They weren't replacing them. They were just trying to get additional people. Okay, so that's kind of just a quick rundown of what you might be experiencing in terms of your school districts across the state. Okay. All right. Something that we had talked about, and I can't remember which session it had been in, but it might have even been in the right from the start, or maybe even the second session that we did. We talked about behavior. We talked about functional behavioral assessments and behavioral intervention plans, and we talked about the regulations that basically apply when you're talking about a student who is whose behavior is impeding their learning or the learning of others. And so this is something that has come out from the public education department. It basically is reiterating what IDEA says, and that is when behavior impedes the learning of that student or the learning of other students, that we have to consider the use of positive behavior interventions and supports to address that behavior. They go on to say a behavior that's integrated into the IEP is that strategy for addressing behavior. IDEA doesn't say that. IDEA doesn't say you have to do an FBA and a BIP when the behavior impedes their learning or the learning of others. There are certain circumstances, and I'll share those with you in just a bit, as to when you do have to do an FBA, BIP under IDEA regulations. But the state has basically expectations for you to be proactive in addressing those concerns. And something I wanted to share with you, and I think I shared with you before, your PowerPoint will have a link to that, and that is this manual. And it is something where you're not going to have to reinvent the wheel, okay? Although it's been last revised in 2010, I think it pretty much stands the test of time. But in here has information on how to do a functional behavioral assessment. And so sorry, let me go back. That's a behavior intervention plan. I was trying to remember these numbers in my head. There we go. So functional behavioral assessment tells you how to go about doing one. It gives you kind of a template for doing one. And so if your school district is struggling, or if your teachers are trying to figure out what that could look like, this manual would give you that idea of what it could look like. That's a functional behavioral assessment. Here is a behavioral intervention plan. What could that look like, and so forth. And then we also have information in here. I think it's on this page. Let me look here real quick. They have basically kind of scenarios for you to follow. Yeah, here we go. So it gives you 10 different students, so to speak. You might have someone who's a bully. You might have someone who's confrontational. You might have someone who, refuses to do work or whatever. So they kind of walk you through 10 different scenarios of what you can do to address a situation and what not to do to address a situation. So I would recommend and encourage you to kind of take a look at this manual. Just make yourself familiar with it. Okay. All right, so we know what the expectation is. That's one of the special factors under IDEA. When we do an IEP, we look at communication needs. We look at whether or not a child might need assistive technology needs. We look at whether or not the child is blind, visually impaired, deaf, hard of hearing, and so forth. But we also look at behavior as being one of those special factors that we have to consider. And so we know that when a student's behavior impedes their learning or the learning of others, we need to be proactive. We need to look at positive behavioral interventions and supports. The public education department defines that as looking at doing a behavior intervention plan. Okay. All right. So when we talk about the discipline process for eligible students, and I put here not yet eligible students, these would be students for whom you might have a concern of them being eligible under IDEA. You're concerned that they might qualify. That would be these not yet eligible students. And I can tell you also, this would apply to your 504 students. Okay, your 504 students have the same protections under IDEA. So, it's really important that we keep that in mind for not only eligible students, but also those not yet eligible or those eligible under 504. So one of the questions I asked on the quiz was one of the things I said, a statement I said was that some students are immune from the discipline process. That is actually false. Every student has, you have the option of implementing or basically imposing discipline on that student. There's just certain protections that may apply for a particular student. And we're going to talk about what those protections are in just a bit. So every student falls under the auspices of the discipline process. You just have to be mindful, and I'm going to go over those protections in just a minute, that these actually may apply to a particular student who's eligible or not eligible. When it comes to disciplining students who are eligible or not yet eligible, we need to make sure that we keep track of those suspensions, short-term suspensions, that we count those days accurately. Something that I just want to warn people about, and I would see a lot of principals do this, and we would end up with a lot of state complaints or even due process hearing requests, is that students would oftentimes be sent home for behavior, just, sent home. And that would constitute a suspension. When you are sending a student home because of behavior, that is a suspension. And so we need to make sure that we count those days accurately, and that we are mindful of how often we are actually sending students home, okay? Any portion of that school day counts as a day of suspension. So, whether you are suspending in the morning or the afternoon, that counts as a day of suspension. We also want to be mindful that we don't use parents as interventionists. We don't want parents to have to come to school and sit with their child to make sure that the child behaves. We are responsible for providing FAPE. We're the ones that are responsible for providing a free, appropriate public education for students, and not the parents, okay? We had a case where a parent actually counted up the number of times she was asked to come to the school and respond to her child. And she ended up turning in a bill saying, okay, I've been an educational assistant, so to speak, in this classroom, and this is what you owe me for coming to school. So again, just be very mindful of that. Maybe call parents after the fact. Let them know, obviously, that, something had occurred during the school day. And that, but everything's under control now. You're just keeping parents informed of something that happened, not asking them to come to the school to intervene in any way, okay? Bus suspensions do count if special transportation is part of the student's IEP. So we want to make sure that we are mindful of that. If we're suspending a student from the bus and we're not providing alternative means for the student to get to school, okay? These regulations do not apply to students who are gifted, unless there's also a disability category. So they might be gifted and also have a learning disability and so forth. That would be applicable. But if a student is just gifted, these do not apply for that particular student. Okay, so these are just some points I want you to just be mindful of as we move on. So I talked about the 10-day rule, and that was one of the things that one of the questions you had on your quiz. IDEA provides 10 school days per year, 10 school days per year, where a student can be disciplined, sent home, suspended, and you do not have to provide services unless you provide services for regular education students, which I doubt is the case. You do not have to provide any of the services that are on that child's IEP during those 10 cumulative days, 10 total days in a school year. It does not trigger the need for a manifestation determination review. You do not have to do what I'm going to talk about as the process, because it does not constitute a change in placement. There are 10 days that you are allotted in that child's school year where you can discipline that student, you can suspend that student, but you do not have to provide services. Oftentimes it's called FAPE-free. There's a law firm that often calls it the FAPE-free zone. FAPE-free zone, meaning we don't have to provide FAPE during those 10 days, okay? doesn't trigger the need for a manifestation determination review. But beginning on the 11th day of suspension, we now owe services. We now provide services. So for 10 days, we don't have to provide it, but on the 11th day, we have to provide it. Okay. All right. Another option that we have is something called in-school suspension. And this is something that we need to be very careful about. It is sometimes overused and abused and can get schools into trouble. And I'm going to share a court case with you in just a minute. But basically, the in-school suspension option for you as upcoming administrators or current administrators would not count as days of removal, would not count as days of removal or a change in placement as long as 3 things are in place at the same time. The student is able to participate in the general education curriculum. They still have access to the general education curriculum. The student continues to receive all of the services in their IEP. So if they're in ISS and they're supposed to have speech, they get speech in ISS or in whatever way, okay? And, see the word and? Small word, big meaning, and they continue to participate with their non-disabled peers to the same extent they would have participated in their current placement. This is often very difficult to do. It's often very difficult to replicate. Some schools have taken basically the idea of, putting a camera into, have the student participate via Zoom or whatever while in ISS. And so now they're participating in their, as they would in their current placement, okay? But just be mindful of the fact that all 3 of these have to be in place for in-school suspension to not count toward that 10-day rule, okay? If that's the case, it does not trigger the need for an MDR, a manifestation determination review, because it's not a change in placement, okay? So these 3 things have to be in place for ISS to not count toward the 10-day rule, for it not to be a change in placement, thus not triggering a need for an MDR. Okay. All right. Well, what is a change in placement then, you ask? Okay. A change in placement happens in one or two situations here. It's when you remove a student for more than 10 consecutive days at a time, or, see the word or, tiny word, big meaning, or you have a series of short-term removals, like you've removed them for 2 days here, 3 days there, 1 day here, 4 days there, and so forth, that will now total more than 10 days that constitute a pattern of removals. And we're going to talk about what that means in just a minute, okay? So either one would be a change in placement. Either the child is suspended for more than 10 consecutive days at a time, or with those series of removals that have taken place during the course of the school year, the child would be more than already be at 10, and now to put them over 10, and there would be a pattern of removals. Okay, so what's a pattern? A pattern of removals is, again, the child's going to be at 10 days, okay, now going to be over 10 days, and the child's behavior is substantially similar to the behavior that the child exhibited before. They're getting into fights all the time or whatever the case may be, okay? And, see the word and here, so both have to be in, all 3 have to be in place. The length of each removal and the proximity of the removals to one another need to be taken into account, okay? So if the child is in a fight, 3 days, fight, 3 days, fight, 3 days, and so on. And also the proximity of the fights. They're close together. That's a pattern of removals, okay? So going back, we have a 10-day rule, 10 days within that school year, cumulative total days where we don't owe FAPE. In-school suspension does not count toward those 10 days if these 3 things are in place. What happens when it's a change in placement? Well, that occurs in one or two different scenarios here. Now we've removed the child for more than 10 days at a time consecutively, and we've had short-term removals where the student has been suspended here and here and here and here for the same kind of behavior, and also the close proximity to one another. If that's the case, we're going to suspend a student. We need to make sure that we inform the parents on the same day of the removal and make sure they get their, what we call the procedural safeguards. And I shared those with you, I think, during the first session. We went and kind of perused what those look like. Okay. All right. If that's the case, this triggers the need for an MDR because it's a change in placement. Okay. So a change in placement is basically triggers the need for an MDR, a manifestation determination review. Okay. All right. So here's a case where we're going to look at whether or not there's a pattern. Okay. A pattern of removals. So this involved a student, I think, out of the state of Minnesota. He had an eligibility category of emotional behavior disorder. He spent 21 days in school suspension in ISS. The district claimed that they basically followed what you had to have in place, meaning, remember, you had to have the student participating in the general education curriculum, student receiving the services on their IEP, and the student continuing to participate with their non-disabled peers to the same extent, okay? So he's been in ISS for 21 days. The district claimed that they had followed those three provisions. Here's what it looked like. In September of 2000, he was suspended 1 day for making a threat. In October of 2000, 2 days for using profanity toward a teacher. In December of 2000, 2 days for work refusal. In December of 2000, 1 day for work refusal and using profanity. In February of 2001, 5 days for profanity and challenging a teacher to a fight. In March, 3 days for possession of cigarettes and profanity. In March, 3 days for fighting. In March, 1 day for failing to comply with requests and using profanity. And then in May, 3 days for work refusal and using profanity. The district's attorney, the school district's attorney, said basically they were all within compliance. They had all those three provisions in place, and therefore it should not have counted as a day of removal or a change in placement. Well, let's see what we hear as the decision. Okay, the Office of Special Education Programs, OSEP, basically said, even if a pattern of behavior does not constitute a change of placement. Remember they said they're following everything they're supposed to follow. Federal law requires the district to basically look at proactive measures to address the need for students when their behavior impedes their learning or the learning of others. And so the IEP team should have come together to look at positive strategies, positive behavioral supports and interventions to address that behavior. So here you had a district that was hanging its hat on the fact that they were following what was supposed to be in place for ISS, forgetting about the fact that, wow, okay, this kiddo spent 21 days in ISS. Do you not think that that would impede that child's learning, right? That's a huge chunk of time for the student to be in ISS. So a lot of learning would be lost. And so here they hung their hat on, okay, we follow the three provisions of ISS, forgetting that they should have been proactive. They should have nipped this in the bud long ago because that child's behavior was impeding his learning, okay? How could it not when you're spending that much time out of the classroom, okay? So I would find this often that would happen whenever a state complaint would get filed. We would be found to be in compliance over the the basis of the complaint, but then the investigator would say, but look over here, you didn't do this or you didn't do that. And so just lessons learned, obviously, okay? All right, well, when we talk about the 11th day, so a student has been removed up to 10 days, and we said that's a fate-free zone, if you will, meaning I don't owe services for that student during that time. On the 11th day, I have to now start providing services for that student, okay? Here's where it varies. It depends on if it's a change in placement or if it's not a change in placement, okay? We already defined what a change in placement is. That's if we do, obviously, a series of removals that will now take the child over 10 days and there's a pattern of removals, or if I do basically more than 10 consecutive days at a time, okay? If it's a change in placement, it's the IEP team that's going to determine the appropriate services for that student beginning on the 11th day. What are those services going to look like on the 11th day? If it's not a change in placement, here's where there can be some conversations with between school personnel. Usually it's the special education teacher along with the administrator. So you as future administrators would have conversations as to what that's going to look like. What are the services going to look like for that student in order for them to continue to participate in the general education curriculum, even though it's in another setting, and be able to progress toward the goals in their IEP. Okay, so difference between whether it is a change in placement or not a change in placement. If it is a change in placement, IEP is going to determine, IEP team is going to determine what that 11th day and beyond is going to look like. If it's not a change in placement, we're suspending. It's not a change in placement, meaning we've gone beyond the 10 days, but there's no pattern of removals, okay? Then the school administrator and teacher or teachers, other service providers can be involved as well. What's that going to look like for that student while being suspended? But because we know we have to provide services on the 11th, beginning on the 11th day. Okay. All right. So somebody had asked what a manifestation determination review is. That's basically the process in which a group of individuals, including the parent and school personnel and others deemed necessary, will come together and basically analyze whether or not the student's behavior has a substantial relationship to the child's disability. Okay, and we're going to talk about that in just a minute. So you have to do that within 10 days of the decision to change a student's educational placement for disciplinary reasons. So when you are going to suspend a student and it's going to be a change in placement, we now have to do a manifestation determination review. And we get it within the 10 days, we get people together to come to the table. During that time, information is being gathered about that student. All the diagnostic information, the grades, the absences, things like that. That's going to be gathered for people to come together to have a conversation about, basically. You're going to give a notice of the meeting to the parent within 10 days. And you're going to give them their procedural safeguards. Make sure they understand what their parent and child's rights are, okay? And basically, you're going to determine whether the conduct in question is a manifestation of the child's disability, okay? Who does this, basically? Well, the IDEA says the LEA, the local education agency, but New Mexico has an expectation for the school administrator responsible for discipline. So if that's going to be you would be at the table. You're the one who's imposing, recommending discipline for that particular child. The parent or parents obviously are going to be there. The student with agreement from the parent, if they obviously haven't reached the age of majority. And then relevant members of the IEP team. Relevant, not required members, but relevant members of the IEP team. You might have other people who are not required members. You might have a social worker who under IDEA is not a required member of the IEP team. You might have the school counselor. You might have a cafeteria worker. You might have somebody else who basically was privy to the situation that happened at the table, even though they're not required members of the IEP team, because you're really having the conversation about the child's behavior and whether or not there's a substantial relationship to what the child did and what that child's disability is. Okay. All right. When you come together, you're going to be asking 2 questions. If the answer to either one of these questions is yes, then the MDR team determines that it is a manifestation of the child's disability, and therefore no disciplinary consequences will happen unless the behavior is classified under special circumstances. And we'll talk about special circumstances in just a minute, okay? So if the answer to either one of these questions is yes, you would conclude that it is a manifestation of the child's disability. No disciplinary action would take place unless, of course, the behavior falls under the category of special circumstances. So what are the 2 questions that you're going to answer? The first question is, was the conduct in question caused by, or did it have a direct and substantial relationship to the child's disability? Was the fighting the child exhibited, did it have a substantial relationship to the child's eligibility category of emotional disturbance, learning disability, autism, whatever the case may be? You're going to do an analysis, okay, between the 2. The second question is, was the conduct in question the direct result of the district's failure to implement the IEP? Did the fact that the IEP was not implemented, was that the cause of the child's outburst or misconduct? Okay. If the answer to that question is yes, the school district is responsible for making sure that they rectify the situation so that never recurs. Okay. So if that second question is answered yes, then the school district has work to do to make sure that that doesn't happen again. Okay. Now, just because some aspect of it didn't happen, child was supposed to get OT, didn't get OT that day, it may or may not have contributed to it. You would have to look through, obviously, all the information that you have on that student to make that determination. Okay. Well, what does that information look like? Well, these are some of the things that are listed in IDEA that you have to look at to consider. The student's IEP, obviously. You want to take a look at the student's IEP. That has an asterisk next to it. That means it's in IDEA. That means IDEA says you have to do it, okay? You would look at, obviously, the current one, maybe one before it, maybe the past IEPs and so forth. Has there been a history of this child exhibiting these kinds of behaviors? You also want to consider information provided by the parents. Is there information that they're bringing to the table that you were not privy to, that you didn't know? Maybe some things were happening at home and so forth that might explain what caused the outburst and so forth. How about the FBA and the BIP for the child, if one exists? Okay, we need to make sure that, was that BIP being followed? Did that student, let's say, was he or she supposed to get a cool down period, and that was basically taken away and not provided for that student, and that caused the child to ramp up the behavior and so forth? Possibly so. As a group, you're going to need to analyze that. Observations and data from teachers and related service providers. That's a requirement as well. Okay, that would help you answer that second question about failure to implement the IEP. Let's take a look at the service logs of that particular student. Did that student, was he or she supposed to go to the social worker that day and miss the session, and something had happened at school or at home or whatever? Okay, so you kind of have to go through and make that and do that analysis. Okay, in addition to that, you'd want to look at the current school performance. What do the grades look like? What do absences look like? Is the child participating in class? Are they turning in homework? Those kinds of things. Those are some of the things that you would want to consider. Obviously, discipline history, behavioral history. Has there been basically a long history of the child? What do the disciplinary referrals look like for this particular student? How about the evaluations and diagnostic results? Was the child referred for this behavior in the first place? Okay, and has that been looked at in terms of goals for that particular student, or a behavior intervention plan and so forth? looking at current medical and psychological information. Is a child on medication and didn't take medication that day? Or is a child, obviously on new medication and maybe there's some side effects and so forth? Take a look at that. And then obviously other pertinent information. This list is not exhaustive by any means, but you want to just look at all the information that you would have at your disposal, okay, to make that determination as whether or not there was a direct and substantial relationship, okay? All right, so if there is a relationship between the two, this is this first question. What were the circumstances that preceded the conduct? What did it look like? What were the antecedents? Is a student in a classroom where there's another student and the two kind of set each other off? Is the student, does it always happen in math class? Because math is a difficult time for that particular student. You want to kind of take a look at that. Has a student exhibited this kind of behavior before? Again, has there been a pattern, not a term of art pattern as in IDEA, but has there been kind of a history of this behavior? And I mentioned the diagnostic evaluations. Was the student basically referred for that behavior in the first place? Are there goals that have been identified that address this particular behavior? Is there a behavior intervention plan for this behavior, etc.? Were there events that were unrelated to this behavior that might have triggered the incident to occur? You know, maybe something happened at home, maybe before leaving the house, or something that happened on the way to school. You're going to basically kind of take a look at that. Was there an impulsivity involved here? Was the student just acting and without thinking, obviously? Over what span of time did the behavior occur? Okay, did it go on and on? Could the student maybe have stopped the behavior? Were there multiple steps involved where the student could have taken time to reflect on the behavior? We had a situation where a student brought a weapon to school, wasn't a drug, wasn't a gun, but basically brought the weapon to school with the intent of, after sixth period, of getting into a fight and harming another student, obviously. And the student was found that it was not a manifestation. Parents said, wait a minute, my child has ADHD, attention deficit hyperactivity disorder. And so, he often acts without thinking. He's impulsive. But the school was able to point out that the student had all day to think about the behavior. He had this planned, okay? So those are kinds of some of the things that you would want to consider. You'd maybe want to interview the student and find out, what do the students say about that particular behavior? I mentioned medications. Are they taking medications, changing medications, and so forth? Is there any evidence that shows video footage of showing the student kind of acting with deliberation? We have some classrooms in my former school district where there, you could tell that the student was actually planning the particular behavior, and other instances where it just happened very quickly. Did the student speak with someone earlier in the day or the week or whatever about the particular behavior? Was there basically a warning that the behavior was going to take place? Okay. When it's that second question about was there a breakdown basically in the students' services and so forth? We failed to implement the IEP. Okay. I mentioned reviewing those service logs and trying to determine, was there causation there? Okay. You want to make sure that you speak with those teachers that were responsible and the related service staff who are responsible for providing the services. And then look at the behavior intervention plan. If one exists, was it followed? Okay. And if not, if there's, as I said earlier, if there's a problem here, then you need to make sure that steps are taken to rectify the situation so it does not recur. Okay. All right. So if you do say that it is a manifestation, there is a substantial relationship between what the child did and the child's disability, you must, IDEA says must, conduct a functional behavioral assessment unless one's already been conducted prior to the behavior that basically caused the change in placement, or develop a BIP, unless, of course, one is already in place. Perhaps you just need to modify it, okay? You would return the student to their current placement and impose no discipline for that student, again, unless it involves drugs, weapons, or serious bodily injuries, which we would categorize as special circumstances. You can change the educational placement of the student as long as the parent and you are in agreement that the child might need a different placement. But that's not a disciplinary move. That would be something that we would look at in terms of maybe another placement would be more appropriate for that student. So in this case, we are not disciplining the student. We're taking steps to kind of make sure that it doesn't recur again, right? By looking at the functional behavior assessment if one exists, or doing one if one doesn't. Looking at the BIP if one exists, modify it if needed, or do a BIP if one doesn't exist. Return the child to their current placement, and then again, without the disciplinary consequences, again, unless special circumstances are involved. Well, if it's not a manifestation, then the student can be disciplined commensurate to a regular education student. So if a student is going to be suspended for the rest of the semester, this student can be suspended for the rest of the semester. We just know that on the 11th day, they have to be provided services. These are services that allow the student to participate in the general education curriculum, progress toward meeting their goals. And then it says, as appropriate, an FBA, behavior intervention services and modifications that would hopefully address that behavior so that it does not recur. Notice it says as appropriate, where if it is a manifestation, you must look at functional behavioral assessment, behavior intervention plan. When it's not, we say as appropriate. And why not, right? We want to be proactive so that that student, the behavior does not end up recurring, okay? All right, well, I mentioned special circumstances. What are they? Basically, they involve weapons, drugs, and serious bodily injury. The idea of special circumstances is to allow you as administrators to keep your campus safe. If weapons are involved, if drugs are involved, or someone has been the victim of serious bodily injury, that obviously is very dangerous in terms of being on campus. And so students can be removed to what's considered an interim alternative educational setting, a separate setting, regardless of whether the behavior is or is not a manifestation of the child's disability. That would include whether they carry or possess a weapon at school or a school function, whether they possess illegal drugs, sell or solicit the sale of illegal drugs while at school or at a school function, and then they inflict serious bodily injury upon another person. And we're going to talk about each one of those, okay? All right, special circumstances, basically there are two provisions. If it is a manifestation, the child is placed in IAES for not more than 45 school days, not more than. That's not an automatic 45 school days. You get 45 school days, but you want to take a look at what is the work that needs to be done behind the scenes so we can get this kiddo back to school and we have the appropriate supports in place and the campus is safe. So you need to figure out what is the work that needs to be done for this kiddo to return. If it's not a manifestation, that student can, again, be given the same consequences as a regular education student. We just know that on the 11th day, the student is afforded FAPE. Okay, they're afforded their services. Okay, so in New Mexico, weapon is defined as any firearm that's designed to, may readily be converted to, or will expel a projectile by the action of an explosion. Any device, destructive device that is explosive or incendiary device, bomb, grenade, or rocket, having a propellant charge of more than 4 ounces, a missile having an explosive or incendiary charge of more than 1/4 ounce mine, sorry, it's covering that. So let me just take a peek there, see what the actual definition is. Hang on. because my screen is covering that. Okay. Hang on, sorry. Or similar device, that's the word that wasn't showing, okay? This definition has come out of, it's similar to the Gun-Free Schools Act. That's the US code. It's also in subsection W of the New Mexico Administrative Code. Remember, I talked about how chapter 31 is the special education chapter. This is actually chapter 11 here, so it does not, it's not specific to students who are in special education, okay? So that's the definition of weapon in New Mexico. Drugs are defined under IDEA as basically a controlled substance, something that falls under schedules 1, 2, 3, 4, or 5 of the Controlled Substance Act. They go on to say basically that a lot of the medications are controlled substances, but they're allowed to be possessed by that person as long as they're prescribed and overseen by a physician, okay? An illegal drug means a controlled substance that is basically not possessed or used under the supervision of a licensed healthcare professional, okay? It's not legally possessed under this particular act. We had a question, Selena.
Yeah, I know you were wanting to wait till the end, but this may need to be addressed right away.
Okay.
So knives aren't included as a weapon, or they are?
Knives are included as a weapon,
Okay.
and I'll show you something in just a moment. It talks about a blade that is, it excludes a blade that is less than 2.5 inches. So 2.5 inches or less would not be considered under special circumstances, okay? Would not be considered under this definition. Okay. Good question though, good question. Serious bodily injury is basically a term, the definition is taken out of the US code, and it is different from bodily injury. They've added the term serious, so it's more than just a black eye. It's more than just a broken arm. I know that sounds horrible. It sounds horrible for a child to have to endure that kind of pain, but basically it's a substantial risk of death. It's extreme physical pain. It's protracted and obvious disfigurement, or it's protracted loss or impairment of the function of a bodily member or a mental faculty. So it again goes beyond the idea of a broken arm or a black eye and so forth, because those do heal. Okay, it's whether or not it's going to be protracted disfigurement or impairment of bodily function. Okay. All right. So I mentioned dangerousness. That was the Honig versus Doe case in 1988, where the administrator, school officials thought that it would be fine to, and within their parameters, to remove a student or students because they were deemed to be too dangerous. Well, there is a provision that has come about that does allow for a suspicion of dangerousness and what can then take place. A school district would then be able to request a court or a special education due process hearing officer who is different from your hearing officers at your local level, okay, to basically petition to them that the student in question is too dangerous to have on campus. That process can take place, that removal can take place through these avenues, regardless of whether the child's behavior is a manifestation or is not a manifestation of the child's disability. We're recognizing, Congress is recognizing that you have the right to keep your campus safe. They're basically removed to an IAES, basically an interim alternative educational setting for not more than 45 school days. And then there's an expedited process that takes place. Okay, so what you'd want to do is obviously consult with your district council. Okay, if you end up having a situation where a child is deemed too dangerous to have on campus. Okay. When that takes place, basically, and a parent is appealing, the student basically stays in that new particular placement that's been determined for the duration of the disciplinary placement, or the decision of the hearing officer, whichever comes first. So whatever decision is made, if that comes before the expiration of the disciplinary placement, then obviously whatever that decision is made, whatever that decision is, then the school district abides by that. It is an expedited process. It's to occur basically within 20 school days because obviously it's a very tenuous situation. And then that decision basically comes down, within 10 school days after the conclusion of the hearing. Okay. I mentioned students who were not yet eligible. They are afforded the same protections. And that is if you had knowledge or you should have had knowledge that the student might be a child with a disability, okay? And so if that's the case, then those students have protection. Either the parent expressed concern, the parent requested an evaluation, one of your teachers expressed concern, or some other staff member was concerned about that particular student. That would be that you were deemed to have knowledge or should have had knowledge that the child might be a child with a disability. In that case, the evaluation must be expedited. IDEA doesn't say what that expedited looks like. Okay, we know we have 60 calendar days to do an evaluation. So obviously something less than 60. Our school district looked at 30, doing that evaluation within 30 calendar days. Okay. You are basically deemed not to have knowledge if the parent didn't allow an evaluation to take place, or refuse the services once they were found to be eligible, or you found the child not eligible, okay? Then the child can be basically disciplined, removed, just like any other student, okay? All right, that was down and dirty. I did a training last week and it was a 3-hour training. So please do look online. I don't know when that's going to be basically edited and placed on the CES website, but you will have an opportunity to kind of get more information in depth. I give information about what's happening kind of across the country when it comes to disciplining students and so forth, what the trends have been and so forth, but also go into more depth in terms of what the IDEA regulations are, okay? Feel free to, we're going to answer questions in just a bit, so put those questions in the chat, okay? But before we do that, I'm going to have Selena put you into groups. We're going to do an activity called You Be the Judge, okay? You Be the Judge involves a student who has attention deficit hyperactivity disorder, and he brings a knife to school, okay? And so he ends up being expelled from school, and the parent then files a complaint or a due process hearing request, basically saying that their child was denied FAPE, that they didn't follow the regulations of IDEA. So here we have a 13-year-old student who out in California has ADHD. He ends up bringing a 3.5-inch knife with a 4-inch metal handle to school. He ends up showing a peer the knife. Staff members end up confronting the student, who basically denies having the knife. When they told him that they would contact police, he said, okay, yes, I hid it in a bathroom stall seat cover dispenser. He never said why he had the knife. Later on, it was months later, he said that he forgot that he had it in his pocket and meant to return it to his Boy Scout drawer before coming to school. The MDR team met and reviewed the student's assessments, which mentioned that he had organizational issues and issues with remembering to turn in assignments. However, they concluded that the conduct was not a manifestation of the child's disability, and they went forward with the expulsion. The school team members reasoned that, given the weight and the size of the knife, that he likely would have noticed it in his pocket, and that they also concluded that his actions on that day were deliberate. Okay, so as I said, the parent filed a due process hearing request saying that they're challenging the MDR. At the hearing, the mother produced 2 letters from doctors stating that forgetting the knife was typical of students with ADHD and attentive type, okay? So parent is saying, you've denied my child FAPE. My child has ADHD. He he acted without thinking. I have 2 doctors who say this is what happens with kids with ADHD, okay? What I'm going to ask you to do is answer the question, did the MDR team reach the right conclusion of expelling the student? So when Selena puts you in your group, you're going to decide, was the answer A, no, they didn't reach the right conclusion because the student has memory problems. B, no, because the doctor's letters indicated that the conduct was a manifestation of that child's disability. Or C, yes, the student's conduct indicated that he intended to bring the knife to school. Okay, so in your groups, you're going to answer any one of these 3 questions. You're going to decide if the answer is A, B, or C. Did the MDR team reach the right conclusion? A is no, the student had memory problems. B, no, the doctors basically said it's a manifestation because we have problems with impulsivity or whatever. And C, the student's conduct yes, they reached the right conclusion because the student's conduct indicated that he intended to bring the knife to school. Okay, let me just have you go into a session for about 5 minutes, have a conversation among yourselves. Selena's going to put you into groups, and then decide on someone who would likely be able to share once we come back out. Okay? Okay, great. Thank you. All right, welcome back, everyone. Hopefully you had enough time to have a conversation within your group as to what you thought the administrative law judge or independent hearing officer would have concluded in terms of whether or not the school team reached the right conclusion. So was there a group that chose A? Was there a group that said, no, the MDR team got it wrong, that the student has memory problems and should not have been expelled? Was there a group that said A? Let Selena know.
You're welcome to unmute and I'll call your name out. Whoever unmutes first. Okay, it looks like no one
No one?
voted for A.
Okay. Okay. Was there a group that picked B? Group B would have said, no, the school got it wrong. The doctors basically indicated that the student the conduct was a manifestation of that child's disability. Did anybody pick B? Okay,
Oh,
Mercy?
hello, wait. Yeah, go ahead, Mercy. Okay, unmute is now available for everybody. Excuse
Okay.
me for that.
Sorry, Selena, I know you had given us a direction and I was like, I don't know what she said to do, but
Okay, sorry.
we were between A and B.
Oh,
And
okay.
we initially were going with A, but thought that it wasn't really clearly indicated that the student had specifically memory problems. We just thought that memory problems are just kind of an issue with ADHD. It's a common issue with
Okay.
ADHD.
Yeah,
So that
okay.
the wording of that. And so we went ahead and went with B.
B, okay.
Given that this was just a piece of evidence that could support what the MD
Okay.
with
What the MDR team needed to
Yeah.
consider? Okay.
yeah, what they needed to consider.
Okay. All right. Thanks, Mercy. Is
You're
it
welcome.
Big Kim? Big Kim?
Hi,
Hi.
that's Bakim.
Bakim. Hi, Bakim.
The group 2, we were kind of divided, if I can
Okay.
say. We
Sounds
were
like
not sure
Mercy.
now between the timeline of when the doctor's letters
Okay.
were, I will say, brought to the district or to the school, and we were between B and C
B and
regarding
C.
this.
Okay. Okay.
But some of us, first we thought it is B because the doctor's note letters indicated the conduct of manifestation of a disability, but then we did not have the right. I mean, I feel like all the information when the letters were sent to the
Oh.
district. Was it prior
Okay,
or after the incident?
yeah. I believe
And
in this case, the parent went to the doctors and the doctors produced the letters after. Okay, okay, good question. Okay. Is it Celine? Wait, I'm not sure we can hear you.
STEM night, so I'm going to mute and they're making an announcement.
Oh, okay. Okay. Good now?
Maybe go with Brian. Since it keeps happening.
Okay, okay, Brian.
Hi there. We were actually leaning towards A, and kind of how we rolled out B and C is we thought that the determination should be made by the entire MDR team, not just based upon one or a couple of letters from doctors that are presented at the meeting.
Okay,
And kind of ruled
Okay.
out C, thinking that it wasn't quite as objective as we would want it to be, that there might be some assumptions that were made there. So we leaned towards A.
okay,
That the memory problems could possibly be a manifestation of his disability, and if that was the case, we would still exercise special circumstances, but then probably go to more of a IAS, not to exceed the 45 days.
okay, okay. All right. So those are great ones for A and B. Was there a group that did C who would like to tell us why? Meaning, yes, the team got it right, that his conduct indicated that he meant to bring the knife to school. Anybody who picked C? Okay, Samantha?
So I think we were kind of in the middle. I just kind of wanted to piggyback a little bit off of B and C, but we did talk about C a lot
Okay.
because the special circumstance topic of that, if that knife and the size of the knife fit right into that.
Yep, 3.5 inches.
We didn't really understand why that wasn't talked about, or maybe we don't know all of the
Okay.
information. Why was that not considered a special circumstance as sort of, kind of the reason why the manifestation happened in the first place?
Yeah, well, I think they
Um,
did consider it as a special circumstance, the fact that it was 3.5 inches. They just said, when he was expelled, parents said, no, he shouldn't have been expelled. There was really, there's a correlation between the child's disability and the child's behavior, which would allow for special circumstances anyway. You're right, because they can remove the child to IAES. It just depends on now the length of time, if it is or is not a manifestation.
And we also
so I
talked
see
about
where
the
you're coming from.
Yes, ma'am. And we also talked about the length of time too. It took a month for the student to come up with, oh, I forgot about it.
Yeah.
So, and we all know how teenagers work sometimes. So
Yeah.
we thought about that too. And just kind of wondered, I mean, where that all fits in. Is there a certain time frame that we I mean, why did it take so long for him to say,
to
I
admit.
forgot? And then we
Yeah,
talked
right.
about
Good
feeling
question.
safe, to being able
Yeah.
to tell on yourself. If you
Right.
open up your backpack and you see it and you're like, oh no, I need
Yeah.
to tell on myself about this. You know what I mean? But feeling
I better come
safe,
clean.
yeah, but feeling safe in order to do that.
To do that. Okay,
So
yeah. Well,
how
they
to
know they
how to
had
manage
10
them.
days to get it done, right? 10 school days to get it done. Okay.
Right.
Okay. Well, those are great analysis. I love how, I really like the way that you all kind of approached it. Obviously, you were given a very short synopsis of the case. There's a lot of information that was lacking, but the conversations that you had were bringing all those up. Remember those, when I talked about the questions and the information you would gather, that's really part of that analysis. So what you guys were looking at you were looking at analyzing that. So let me give you the answer. Okay. I know people have other things they'd like to say, but let me give the answer so we don't run out of time. So the decision was C. Yes, the student's conduct indicated that he intended to bring the knife to school. Here's what it said. Given the student's actions of the day of the incident, it was reasonable for the MDR team to determine that bringing the knife to school was a conscious choice, not a memory lapse. The ALJ, administrative law judge, stated that if the student genuinely took the knife to school by mistake, it was unlikely that he would have opened it and displayed it to another pupil or concealed the conduct. Moreover, it was likely that the student would have explained his mistake to staff members, but he didn't do that even after he was caught. Finally, this was a heavy metal knife with a substantial blade, the ALJ observed. It was reasonable for the MDR team members to doubt that the student would not have noticed it in his pocket. Okay, so basically, they said A is incorrect. Evidence of the student's memory issue was outweighed by indications that the student acted deliberately. B was incorrect, reasoning that the snapshot rule applies to MDR meetings, right? You're taking a snapshot of what did the student do? Look, compare that to obviously the student's disability, that the team's decision was objectively reasonable based on the information before it at the time. So good job. I love how you guys were like contemplating between A and B or between B and C and just what you use to analyze it. You know, that's the important part. Coming together, taking a look at the information. Obviously, this is a tiny synopsis. You would have a lot more information at your disposal. You'd have the diagnostic information, you'd have the IEP, you'd have grades, you have absences, you'd have, you know, reports, service logs, all kinds of stuff that you would consider as a team. So good job. Good job. Okay. Selena's going to pull up the poll and we'll see how we did based on the information that we covered. One thing I didn't mention when we talked about drugs is so alcohol and tobacco would not be considered a drug. You would go ahead and you know, impose disciplinary action for a student possessing obviously tobacco or being under the influence and so forth, or possessing alcohol. But it wouldn't fall under the auspices of special circumstances. You wouldn't have that interim alternative educational setting option for students, okay? But I forgot to mention that as we were going along. So, all right. So before we conclude today, we'll have a chance to kind of talk about what we're going to talk about next and then answer any unanswered questions. And if there are questions that we don't get to, I always answer the questions, get those to Leanne and Tara, and they get those posted. So look for those if those questions aren't answered this evening, okay? So here's how we did in terms of the quiz. The statement was certain students are immune from the disciplinary process. That would be false. So most of you said false, that the answer would be false. Remember, no student is immune. We just have to look at those protections. We have to look at how many days have we suspended? Do we need to do a manifestation determination because it's going to be a change in placement and so forth, okay? All right. Number 2 says an eligible student may be removed for 10 or fewer cumulative total school days in a school year due to a disciplinary infraction and not receive services per their IEP. The majority of you said true. The answer is true. Remember, we have 10 days, 10 FAPE-free days in a school year where you do not have to provide the services. You would only do it if you provide that for regular ed students. I don't know of any school that suspends a regular education student and then still provides the services for those students. Number 3 says an example of a change in placement regarding disciplinary actions is a series of removals that constitute a pattern. Looks like just a little bit of you, the majority of you said pattern. We look at a pattern. Is the behavior substantially similar to the behavior in the past? Are the infractions close together? Are they in close proximity? And will that next disciplinary action imposed now cause that student to go over 10 days? Okay, so that would be a pattern. Number 4 says within blank school days to change the educational placement of this child's for disciplinary reasons, an MDR must be conducted. You have to do that within 10 school days. The majority of you got that one correct. Number 5 is members of the MDR team include the school administrator responsible for disciplinary actions. That's per New Mexico. That's the expectation. Parents, student with agreement from parent, and relevant members. That was almost split. Relevant members from the IEP team. Basically, you're bringing in other people who have relevancy to the meeting. They have information about the student. Maybe they've been working with that student, in another capacity and so forth, or they were part of that incident that happened. You'd want to bring those people in, okay? Following 10 cumulative days of removal in a year, a student's services are determined by an administrator and at least one of the student's teachers for subsequent removals that are not considered a change in placement. That one is true. That one is true. So if it's not a change in placement, if it is a change in placement, the IEP team is going to determine what those services are going to look like. If it's not a change in placement, that can be typically the special education teacher along with administrator or some other person at the school. What's that going to look like on the 11th day for that particular child? Okay. Number 7, if a student's behavior is determined to be a manifestation, the LEA can still move forward with discipline, even if it's categorized as special circumstances. That's true. The majority of you got that right. It doesn't matter whether it is or is not a manifestation of the child's disability. When it involves drugs, weapons, serious bodily injury, we can remove that student to an IAES. How long they stay there is dependent on the work that you need to do behind the scenes for pulling that child back. And it also is contingent on whether it is or is not a manifestation of that child's disability. Remember, if it is, we're talking no more than 45 days. If it is not, that child can be disciplined commensurate with a regular education student. Okay. Number 8, beginning on the blank day of suspension, the student must be provided with a FAPE. It is on the 11th day because you have 10 days every school year where we don't have to provide FAPE. Number 9, I forgot to mention this to you, but was able to do it just a minute ago. Alcohol and tobacco would not be considered under special circumstances. You still would be able to impose disciplinary actions, just not under special circumstances, okay? And then the last one says one of the 2 questions that you have to ask is, was the conduct in question a direct result of the district's failure to implement the IEP? Most of you got that one right, okay? Yes, that is one of the questions. And if that's the case, you have to figure out what went wrong and we need to fix it. We need to do something different, okay? All right, good job, everyone. All right, next time we are gonna conclude our 6-part series, and I just kind of wanted to give you an idea of what we're gonna cover. We're gonna cover independent educational evaluations when parents request an IEE. We're gonna cover bullying and how FAPE may be affected for a student who is a victim of bullying and what your obligations are, because there is guidance from Office of Special Education Programs and Office of for Civil Rights. We're going to cover extended school year services. What does that look like, and what students might you consider that for? We're going to talk about private school reimbursement requests. When a parent takes their child out of school and says, okay, you didn't do what you needed to do for my child, I'm going to place them in private school and you're going to reimburse me for that tuition. We're going to talk about transition needs for students who are in the state of New Mexico at no later than the IEP of when the child's 14, okay, younger if needed, but no later than the child that's going the IEP that's going to be in effect when the child turns 14. We have to look at transition needs, and there are some changes that are coming, by the way. I'll talk about those. We're going to talk about restraint and seclusion guidelines, what you have to follow, because that is not just for students in special education, but all students. And then we're going to talk about what you have to do for addressing chronic absenteeism and the relationship to FAPE with that. Okay. So that's what we're going to cover for our last session. You can see that's kind of a hodgepodge of things, but we've got just a few seconds remaining, and I just want to take the opportunity to say thank you for joining me tonight. I know it was kind of down and dirty, and hopefully I was able to make some sense of it. If you have questions, independent questions, you're welcome to email me. My email is on that first slide, the title slide. You're welcome to do that. Selena's going to take any questions that are in the chat that we didn't get to. I will answer those. I will get those out typically by Monday, and also get that to Tara and to Leanne, and then they will get that out to you so that you will have answers to that. So